Let's now turn to another limitation on the recovery of contract damages, the doctrine of mitigation. Under this doctrine, the non-breaching party is not permitted to unreasonably worsen or aggravate the damages to which the breaching party will be held liable. In general, there is no reason other than spite or stupidity for an injured party to unnecessarily increase the damages imposed on a breaching party. The injured party is entitled to its lost expectation, no more, no less. Unnecessarily increasing the breaching party's damages will not result in the injured parties being put in a better financial situation. The basic principle for mitigation of damages is set forth in Section 350 of the Restatement Second of Contracts. Though courts often speak of the non-breaching party's duty to mitigate, in fact, it's not a duty at all. Rather, it's a limitation on the amount of damages that the non-breaching party can recover. The principle of mitigation prohibits the non-breaching party, as a result of bad faith or unreasonable action or inaction, to aggravate the damages caused by the other party's breach. The breaching party will not be held liable for increased damages that result from the injured party's failure to mitigate. In general, the principle of mitigation takes a sympathetic eye to the non-breaching party. After all, the non-breaching party was placed in the position of having to salvage what she can from the bargain by reason of the other side's wrongful breach. Accordingly, the injured party is not required to take the most efficacious steps to minimize the damages. The steps it takes must simply be reasonable under the circumstances, irrespective of whether another approach may have lessened damages to a greater extent. Subpart 2 of Section 350 makes clear that so long as the non-breaching party takes such reasonable steps to mitigate, it will be entitled to recover damages, even if those steps were unsuccessful. It is only where a court determines that the injured party's response to the breach is clearly improper that the mitigation principle should keep the breaching party from bearing the increased loss. Moreover, the burden of proof with respect to mitigation supports this sympathetic approach to the injured party. Once a party has proven that it suffered damages as a result of the defendant's breach, proving that the plaintiff failed to take reasonable steps to mitigate is treated as an affirmative defense. The determination of whether the plaintiff's steps taken to mitigate were reasonable is obviously a highly fact-specific determination. Moreover, it's an objective determination that is governed by a reasonableness standard. Were the steps taken by the plaintiff after the breach ones that a reasonable person would have taken under the circumstances? Subpart 1 of Section 350 makes clear that the injured party does not have to take steps if they involve undue risk, burden, or humiliation. So let's consider an example. Assume that Joan entered into a contract with William, a graduate student, who is studying cello at a local university, to give her cello lessons. Joan agrees to pay William $50 per lesson, and William agrees to come to Joan's home on a weekly basis. Halfway through the year, William leaves town, breaching the contract. What steps can and must Joan take to mitigate the damages that will be imposed on William? So let's assume that she decides to hire a new cello teacher. May she hire the renowned cellist Yo-Yo Ma at the cost of $1,000 per lesson to take William's place? The answer is obviously no. Taking reasonable steps to mitigate requires that the injured party seek to replace the performance that the breaching party was to provide at a comparable cost. The cost of the substitute need, however, only be roughly in the same price range. Surely Joan could have found another cello teacher far cheaper than Yo-Yo Ma to give her lessons. She will only be able to recover the difference between the going rate in her community for cello teachers and what William was charging. It is not reasonable to hire a world-renowned cellist to provide the substitute performance. Nonetheless, if the only available substitute teacher is one who is more highly qualified and therefore more expensive than William, within reason, a court will award damages to Joan to cover the difference between the fee charged by the new teacher and the fee William charged. This principle is well illustrated in the Handicapped Children's Education Board versus Lukashevsky case, where the defendant's speech therapist breached her contract by resigning. The only available substitute was a more highly qualified, more expensive teacher. Nonetheless, the court awarded the plaintiff the cost of the difference between the new teacher's salary and the salary it had contracted to pay the breaching defendant. So let's now consider the reverse case, where it's Joan who breaches the contract, not William, the cello teacher. Assume that after 6 months of the 1-year contract, Joan breaches the contract by informing William that she no longer wants to take cello lessons from him. May William sit idly by on his couch for the next 6 months and then sue Joan for the remaining amount due on the contract? The principle that the non-breaching party must take reasonable steps to mitigate suggests the answer is no. Instead, William must take reasonable steps to find a substitute transaction. In other words, to find another student to fill the time slot that Joan had occupied. Such reasonable steps might include advertising in local newspapers or perhaps on community centers' bulletin boards. If, after taking such steps, William's unable to fill the slot, Joan will still be responsible for the entire loss. If, however, he does find a substitute student, then the damages for which Joan is liable will be reduced by the amount that William earns from the replacement lessons. There are clear limits to what reasonable efforts the non-breaching party must take to mitigate damages. Should William have to take a part-time job at a local hamburger restaurant to replace the income he earned from his contract to teach Joan cello? It's doubtful that a court would determine that mitigation required William to pursue alternative income outside of his chosen profession. This might be deemed to fall within the humiliation exception to the requirement that the injured party mitigate damages. An important exception to the mitigation principle is the so-called lost volume situation. To illustrate this principle, let's return to our hypothetical involving William and Joan. In that case, William has a limited number of teaching slots that can be filled. If one such slot is opened up by Joan's breach, it is clear that a new student filling that slot is a substitute for Joan. The new contract is a substitute transaction, one William could not have entered but for Joan's breach. As such, the fees that William earns from the new contract will be deducted from any damages he is able to prove resulted from Joan's breach. But assume now that William's teaching schedule was not full at the time of Joan's breach. In such a case, William could have taken on a new student even had Joan not breached. In such a case, if William accepts a new student after Joan breaches, that student is not a substitute for Joan. This is clear if the new student is scheduled for a different time slot than the one previously filled by Joan. But even if the new student fills the same time slot, he should not be viewed as a substitute for Joan because William's dance card was not full to begin with. Accordingly, in such a case, the additional income that William receives from a new student should not be deducted from the damages he receives from Joan as a result of her breach. In general, it is only in instances in which the breaching party can prove that the plaintiff could not have entered into the new contract absent the breach that the new contract should be viewed as a substitute for the breached contract, and thus deductible from the injured party's damages. Let's consider another lost volume situation, one exemplified by the Jet Service Company v. Selena Properties case in our casebook. Sometimes a business can undertake a seemingly endless number of additional contracts. A clear example is an internet service provider, which may have contracts with thousands of businesses. Such a business can virtually always take on an additional client, given the vastness of the company's servers. Thus, if one client breaches a contract with the service provider by not paying its bill, the loss of that client does not open up space for a new client. The space already existed. As such, the internet service provider should be entitled to recover its full lost profit, without being required to show that it mitigated by seeking a substitute transaction.